Welcome to Crime in Court. My name is Heather, and this is another update in the Delphi case. We are obviously talking about Indiana versus Richard Allen, and this is in the search for justice for Abby and Libby. And we're going to talk today about what happened last Friday. So, there was a hearing on Friday and there was a bunch of documents that dropped, short little documents. So this is going to be a pretty short video. So let's get to it. Please hit the like button and let's begin. So I'm going to start us off with this news clip from WRTV ABC. So what happened was in some local station in Indianapolis. So what happened was there was a hearing on Friday, and part of it was going to be closed to the public, and then the other part was going to be open to the public. Well, the part that was open, the public actually was turned away, and it was kind of a weird way in which it was done, and there's no real explanation. So let's watch this news clip and have them explain what happened.
An unexpected turn of events in Delphi today. The man accused of murdering Delphi teens Abby Williams and Libby German appeared in front of a judge. Well, part of that hearing involving Richard Allen was supposed to be open to the public. But as WRTV's Rachel Wilkerson reports, that didn't happen.
We never made it inside the Carroll County courtroom. The day began with a closed status hearing. About 35 minutes into that hearing, a deputy came out and told us there would be no public hearing. When asked why there was a change in what happened, investigators shrugged. There is no transcript of today's proceedings, and everyone involved is under a gag order. The families of Abby Williams and Libby German did meet privately with prosecutors and investigators. Meanwhile, Allen's family was in the hallway crying, confused about what was going on. Defense attorneys then met with them. There were 4 new motions filed today. The bottom line is the defense is
And we're going to read those.
pushing to speed up the process when it comes to receiving documents. They say they
want their discovery faster. We're going to read about that.
want them in 15 days instead of 30. Both sides must have their evidence in by October 1st. The trial is set for October 14th. Some of those requested records involves the doctor who cared for Richard Allen during his time at Westville Correctional Facility. The physician testified in a previous pretrial hearing that she was aware of the Delphi murders and knew who Richard Allen was. The defense claims that doctor was investigated after pretrial comments and wants access to those findings. The state also wants to prevent its own witness from getting on the stand next week, along with 2 others. That's because the judge has not ruled whether or not these third parties can be mentioned during the trial. The state also claims that the defense is trying to annoy, embarrass, and oppress them. In Delphi, I'm Rachel Wilkerson.
Say that again.
Not these third parties can be mentioned during the trial. The state also claims that the defense is trying to annoy, embarrass, and oppress them.
The state, Nick McLeland, is arguing that the defense is trying to annoy, what was it? Why can't I remember 3 things in a row?
The state has not ruled
Which
whether or
part?
not these third parties can be mentioned during the trial. The state also claims that the defense is trying to annoy, embarrass, and oppress them.
Annoy, embarrass, and oppress them. So Nick McLeland is arguing that the defense team is trying to annoy, embarrass, and oppress the state. Yeah, exactly. That's their whole purpose in life is to annoy, embarrass, and oppress the state. No, they're trying to defend their client whose life is on the line for a crime that he very likely did not commit. Anyways, so yeah, that's what the state thinks. So let's get into these filings real quick. Let me swap scenes. All right, here we go. So the first document that we're going to read is the Delphi decorum order. So Judge Gull came out with this order on Friday, or actually, no, I think she came out with it sooner than Friday, but I haven't read it yet on my channel. So here we go. Courthouse management and decorum order for the hearing August 23rd. Oh, this was for the hearing that was supposed to happen. So we don't even need to read this. Sorry. Um, yeah, this was just for the hearing. So seating's limited. I'm just trying to see if it says anything about the open to the public. All members of the public and the media are required to follow these rules. Okay, no court-produced recording will be made available, blah, blah, blah. It doesn't say anything, nothing about the public hearing and the private hearing or anything along those lines. So this was not very helpful. First row of public seats behind the bar separating the well of courtroom from the public is unavailable for seating. Okay. No one can stand. Yeah, it doesn't say anything. I mean, there wouldn't have been decorum uh, instructions if wasn't a public hearing. But yet, here we are with no public hearing. So there you have it. So they had a public hearing on Friday, and yet it wasn't public. They just shooed people away. It was one of the officers. I think it was Liggett. It might have been Liggett. I heard. I'm not sure, but somebody just kind of came out with like, "Time to go." We don't know why, but you ain't coming in, and it was really awkward and weird. All right, so up next, the motion for order to shorten discovery response period comes now the defendant, Richard Allen, by counsel Bradley A. Rosie, and respectfully request, pursuant to Rule 26 and Rule 34 of the Indiana Rules of Trial Procedure, that this honorable court shorten the time frames for third parties, Indiana Department of Corrections, and the Indiana Attorney General to respond to defendant's request for production to non-party dated the 23rd of August. Yeah, I mean, heck, they had trial scheduled October, what did he say, 17th, 14th? I can't remember now. One of those days, the 14th or the 17th. And yet we are giving them a 30-day turnaround time. So that means you're just going to get it at the very end of September, which means you have very little time to review it. In support of said motion, Defendant Allen states as follows. 1. Defendant Allen is the accused in this matter. 2. The jury trial is in this case October 14th. Sorry. I knew it was one of them. All right, 3. The parties are in the process of conducting discovery and have been ordered to exchange a list of trial exhibits by October 1st. 4. The mental health services provided by Dr. Monica Walla were called into question during pretrial proceeding in this cause on or about July 31st. That's when they had a hearing about it, and Monica Walla was called in to testify. Number 5, Defendant Allen has reason to believe that further employment-related investigations associated with Dr. Wallace's conduct were carried out after said pretrial proceedings, and therefore, Defendant Allen is pursuing information related thereto. So there was some sort of investigating into Dr. Wallace's uh, her social media presence and things like that and her conduct in this case because the whole thing was because, in case you're confused, I should have explained. So Dr. Walla is a mental health professional who was evaluating and I think treating also Richard Allen. Yeah, she was treating him because she's the one that put him on the psychiatric drugs or antipsychotic drugs. So Dr. Walla was evaluating and treating and um was also in like these uh Richard Allen social media groups like Justice for Abby and Libby groups and things like that she was in. So her testimony came into question. Where was I? All right. So, and they want all the information that they have on that might have come up. Number 6, Defendant Allen intends to tender the attached non-party request to each of the referenced non-parties and seeks a waiver of the 15-day response period required by Rule 34C of the Indiana Rules of Trial Procedure. Number 7, Defendant Allen further seeks an order shortening the 30-day response period permitted by Rule 34C to Defendant Allen's non-party request for production of documents. Number 8, Defendant Allen seeks the shortened time frame in an effort to allow for adequate time to review any discovery received, conduct any further discovery necessary based upon the receipt of of information, and to consider whether or not said discovery will be included in the trial exhibit lists, which must be exchanged by October 1st pursuant to the court's prior orders. So, Judge, we're not going to have time to review this, get, our own investigating done and get, hire an expert or whatever we might need in a short amount of time. We can't do that. So, yeah, can you please shorten this time frame? Because end of September doesn't work for us. What was it? September, so August 23rd, so they might not get the information until September 23rd, and then they have to hand over their list of what exhibits they're going to use by October 1st. So they get it, what, September 23rd, and they have just a few days to turn that around. That's really cutting it very, very close. All right, so number 9, specifically, Defendant Allen seeks an order eliminating the 15-day notice period of the state of Indiana. 10, Defendant Allen seeks further seeks to shorten the 30-day response period by the Indiana Department of Corrections, Indiana Attorney General to 15 days. And 11, said request to shorten the time frame is not unduly burdensome on the state or any of the third parties. And finally, 12, Defendant Allen believes that said request is in the interest of judicial economy because it is in fairness to our client to have more time to evaluate the info. So there we have it. Also, they made a second motion for order to shorten discovery. Comes now Defendant Richard Allen by counsel Bradley A. Rosie and respectfully requests, again pursuant to Rule 26 and Rule 34 of the Indiana Rules of Trial Procedure, that this honorable court shorten the time frame for third parties, Centurion, Indiana Department of Corrections, and the Indiana Attorney General to respond to defendants' requests for production to non-party related or dated the 23rd of August of this year. In support of said motion, Allen states: 1, he's the accused. 2, trial set for the 14th. 3, they have to give over their trial exhibit list on October 1st. Number 4, mental health services provided by Dr. Waller were called into question during the hearing on the 31st of July. Number 5, Defendant Allen has reason to believe that her conduct was looked into, and we want that info. Number 6, said requests were served on the state via email attachment on August 13th. The state of Indiana declined to waive the 15-day notice period when said waiver was sought out by defendant's counsel. The 15-day notice period is set to expire on or about August 28th. Number 7, counsel intends to direct the non-party request for production to the relevant parties on August 28th in the absence of any motions filed by the state between now and that time. Number 8, counsel desires that the 30-day response period by the Indiana Department of Corrections, the Indiana Attorney General, and Centurion provided for in Trial Rule 34C be shortened to 15 days. Number 9, said request to shorten the time frame is not unduly burdensome on the third parties. Number 10, counsel believes that it is in the best interest of judicial economy that the court issue an order shortening the time frame for said non-parties to respond from 30 days to 15 days, with the 15 days time frame to commence immediately upon service of said request of the non-parties. We need our stuff. Judge, please hand it over or make them hand it over. This is really blurry and it's hard to read, but I'm going to do my best here. All right, so we have lastly 2 motions to quash. Now comes the state of Indiana by prosecuting attorney Nicholas C. McLeland and pursuant to Rule 45B of the Indiana Rules of Trial Procedure requests that the court quash the subpoena issued for David Schilling to be deposed in the above questioned matter. So the defense has found someone by the name of David Schilling and they're going to depose him or have plans to depose him on August 28th. So, in support, we don't know why, but the state wants to stop them from deposing him for whatever reason. So, in support of said motion, the state asked the court to consider the following: that the defendant served the state with a subpoena to depose David Schilling on August 28th, 2024. How did they serve it to them in the future? This, as I'm recording this is August 26th. So I don't know how they served the subpoena. Oh, to depose him on the 28th. So his deposition is scheduled for the 28th, I guess. Is poorly written. Bad grammar makes confusing sentences. All right. So that David Schilling is listed as the state's witness, that the state listed him as a rebuttal witness to testify as an expert on Odinism. Oh, so he's a state's expert, and the defense wants to depose him on Odinism. And the state wants to stop that for some reason. That the information on Odinism has been challenged by the state in a motion in limine where the state has asked the court to exclude any testimony in relation to Odinism from the trial. Well, she hasn't ruled on it yet, so they have every right to depose him on Odinism. Number 4, that the state believes the deposition of David Schilling is unreasonable. Telling you, it's blurry. It looks less blurry on your screen. Maybe I should read that. It's just way smaller. All right, so that the state believes the deposition of David Schilling is unreasonable in that it is not relevant to any issues in the case. The state believes the testimony of the deponent is not relevant and is not exculpatory in any way to the defendant. That's okay if you, Nick McLeland, doesn't believe that, but that's okay if the defense has another belief or thinks differently. So they can still depose him and try to get that information, even if you think it's not relevant or you think that, what did he say, that it's not relevant or exculpatory. Well, you might not think that, but maybe the defense thinks that, and that's why they want to call him or depose him. So you can't call him and have it just your way. Doesn't work that way. So why are you calling him that? Why is he on your list? If you don't want Odinism talked about in the first place and he's a rebuttal expert to testify on Odinism, why do you even have him as an expert on your expert witness list? Am I losing my mind? I mean, you don't want Odinism talked about in the trial, but yet you have a witness prepared to talk about it. Okay, whatever. I guess in case it slips or just to be prepared. All right, so the deposition is set for August 28th, 2024. The state reached out to the defense to attempt to move the deposition until after the court has made its ruling on third-party motive, but the defense refuses to move the depositions. I would refuse too. I'd be like, what the heck do you know about Odinism and what can you tell me that could be helpful to my case? Wherefore, the state asks that the court to issue an order quashing the subpoenas and for all other just and proper relief in the premises. So he wants the subpoena that is that was sent to David Schilling. She wants her to stop it. Nick McLeland wants Judge Gull to quash it, means end it, make it no longer so. So he's got a subpoena to be deposed on uh what is that, Wednesday of this week, and this came out last Friday. So yeah, you're cutting it short, buddy, Mr. McLeland. And that he's not done. He's got another motion to quash. And now comes the state of Indiana by prosecuting attorney Nicholas C. McLeland and pursuant to Rule 45B of the Indiana Rules of Trial Procedure requests that the court quash the subpoenas issued for Patrick Westfall, Nick Westfall, and Tobe Lesenby. Do he deposed in the above to be deposed in the above caption manner? I think that's an error, a typo. He says do be deposed. That's a 2. Anyways, all right. So in support of said motion, the state asks the court to consider the following: that the defendant served the state with subpoena to depose Patrick Westfall and Nick Westfall. So that must be Patrick Westfall's son, or relative or somebody that was with Patrick Westfall or could speak to his whereabouts. And that's also supposed to be done on the 28th of this week, Wednesday of this week, and then Tobe Lesenby on September 13th. So Tobe Lesenby, remember, is an investigating officer from, I think he's state police, but I can't remember now. There's so many of them. I did a who's who and went through like who's with what agency and all that, and that was a good little deep dive of all the people involved. All right, number 2, that the state believes the depositions of Patrick and Nick Westfall are unreasonable in that they are not relevant to any issues in the case. The state believes the testimony of the deponents is not relevant and is not exculpatory in any way to the defendant. Well, then why fight it so bad? Why do you not want them to, if there's no exculpatory evidence, why can't you let them be deposed and let them ask questions? And if the state is alleging what it's saying and that these things are true, Patrick Westfall's own, alibi and whereabouts, they trust that and blah blah. Okay, well, the defense still has a right to ask the questions. They still have a right to talk to these people through depositions and trying to find out what they know, trying to ask questions like you would in a regular deposition. So it just baffles me. Why is the state trying so hard to keep them from doing so? In a deposition, you can, there's no judge around, but the attorneys from both sides are there, and the, person who's being deposed might have an attorney. And you could pretty much ask a whole bunch of questions that you might not be able to ask at trial because there's no judge stopping you, and there's no, I mean, you can object, but doesn't mean that you can't answer the question. You still should be able to answer the question unless your attorney advises you not to, but whatever. So a deposition is something that, would really help the defense if there is some kind of Patrick Westfall ties to this, and just trying to figure out what's going on. So it would definitely help them in their defense with a third party. Obviously, since Judge Gull hasn't ruled on the third party, Nick has kind of a say in maybe like stopping these until she rules. Hopefully not, because that's supposed to be Wednesday, but we'll see. Um, So yeah, Patrick Westfall and Nick Westfall must be related. So he thinks it's not relevant to the case, but the defense could think it's relevant. So you gotta let them do their depositions. And she's probably gonna deny, or she's going to approve this one, and then block the defense probably from doing this depositions with it, which I think is a shame if I could get words out of my mouth. All right, let's move on. So the state believes the testimony of the deponents is not relevant and is not exculpatory in any way to the defendant. Again, you can believe that, Nick McClelland, but the defense can also believe their own theory. Further, that a deposition is an effort by the defense to annoy, embarrass, or oppress the deponent or party. Well, there you go. So again, Nick McClelland throwing shade at the defense. Constant shade is thrown at the defense in these filings from McClelland and Judge Gull. This is ridiculous. The depositions of these deponents is set for August 28th. The state reached out to the defense to attempt to move the deposition until after the court has made its ruling on third-party motive, but the defense refuses to move the depositions. They already have the subpoenas. So she would have to go and quash them, which means stop them. So the subpoenas have already been issued to talk to these folks. So um, some judge thought it was important to talk to these guys. I don't know. But and here Tobe Lesenby, that the state believes the deposition of Tobe Lesenby is cumulative and oppressive in nature. Really? Really? 1 second. Right here. So Tobe, yes, no, I was wrong. Tobe Lesenby is the chief deputy, so I believe he's like the second in command for Carroll County, for the Carroll County Sheriff's Office. So, whoops. This was part of my slide, or my presentation on these folks, on the who's who. So yeah, Tobe Lesenby is the chief deputy of Carroll County. So just wanted to point that out. Okay, so Tobe Lesenby. All right. State believes it's cumulative and oppressive in nature. The state believes that the deposition is being done in bad faith in an effort to annoy, embarrass, or oppress the deponent or party. No, I'm sure it's not. I'm sure they want to get to the bottom of the information. They want the truth. Lesenby was deposed on August 9th, 2023 by the defense. The state believes that all relevant topics were covered by the defense in that deposition. Oh my God, do you know how much has happened since August 9th of 2023? There's so much more things that have happened. They got different discovery back from the state when they got put back on. So they might have different things that they want to go over. I bet you there's going to be some replies to these motions to quash because the defense has probably good reason to depose these people. They probably found new information or something that they didn't talk to Lesenby before about, and now they want to cover more ground with him. So, plus, I mean, there's nothing wrong with deposing somebody twice. There's been so many years since this case has since the crime happened till we're going to trial, and it's been prolonged and prolonged. So there's nothing wrong with deposing somebody multiple times. I mean, if necessary, you don't want to do it needlessly, but if you have to, you have to. So the state believes that all relevant topics were covered by the defense in the deposition, that the state believes the defense intends to cover the same topics in an effort to harass, annoy, embarrass, or oppress Tobe Lesenby. Wherefore, the state asks that the court issue an order quashing the subpoenas and for all just and proper relief in the premises. Signed, Nick McClelland. So that is the end of that. And that's all I got for you. So I told you it was going to be a short one. I probably am expecting to see some replies, maybe even some replies to these 15-day discovery turnarounds, perhaps, but it's not the state. So the state can't really object and it doesn't really affect them. So, because their motions for discovery are with other outside agencies. So that shouldn't affect anything coming from the state. Um, but just these depositions with David Schilling, the Westfalls boys, Nick and Patrick, and then Tobe Lesenby. So we'll see if they go forward this week. We have it's afternoon. Have not heard yet from Gull Monday, August 26th, regarding any of this, regarding the third. We're still waiting on the third party culprit. Will the defense be able to use it as their defense? We'll see. She has not ruled on that yet. And then now we're going to wait on this motion to quash. I kind of think the defense is going to push back because they've got a purpose. They have a reason to subpoena these people and to depose them. And yeah, so I think they're going to push back. What do you guys think regarding the motions to quash or the secret, uh, the public hearing that suddenly didn't happen? What do you think happened there? Let me know your thoughts in the comments below, and I'll see you guys in the next one. Take care, and thank you so, so, so much for watching. Bye, guys.